Okay, we're officially recording.
How exciting.
Yeah.
Hey, amazing. So glad to have everybody here. We have more of a turnout than usual, so this is exciting. And today we're going to be talking about the life cycle of a mergers and acquisition deal. And we have two very experienced, very amazing and intellectual lawyers to talk to us today. So I'm just going to start off with Siobhan Lennox. I'm going to read a bit of her bio for you all. So Siobhan is from the UK. She studied at the University of Newcastle upon Tyne, where she obtained her bachelor's in government and European Union studies. Then she worked for the Regional Development Agency in Yorkshire. And then she obtained a graduate diploma in law from Leeds Beckett University. She then went on to do her legal practice course, and then her training contract was at Corbett LLP. That is a top 50 UK law firm. She then went on to enroll as a solicitor in England and Wales. And then she moved to Canada, where she started off as a legal assistant at McCarthy Tetrault LLP. And then she completed her articling at O'Neill Law LLP. And now she's practicing as a cross-border corporate commercial and secretary associate at O'Neill Law LLP since 2018 till now. So that is impressive. Well done, Siobhan. And then we have Eric Ratnayake, who is a lawyer with Ketchena Law Firm. Do I got the name right? Ketchena Law Firm in Ottawa.
Ketchena Law.
Okay, Ketchena Law. Correct?
Yeah.
Yeah. That's
okay.
Correct.
Yeah. So he is a commercial lawyer at that law office. He has experience advising and representing public and non-public companies across multiple industries, including financial institutions, tech startups, small businesses, pharmaceutical companies, and government agencies. He also graduated from the UK, from the University of Leicester to be specific, and then he moved to Canada and started working as a commercial lawyer. So we're going to have the both of them address us today. So I'm not sure who we're going first with. Siobhan, is it you?
Yeah, I think we're actually going to sort of tag team between the two of us. So we'll see how this goes. Hopefully this works. Fingers crossed.
Okay, so Siobhan, do you want to tell us about the life cycle of a mergers and acquisition deal?
Absolutely. So hopefully you can all see the slides. Fingers crossed, thumbs up. I'm always worried that when we do this, that technology is about to fail us. These slides will be available afterwards, so we will email them to everybody. They'll also be in the GLC members only Facebook group. So if you're not a member of the GLC members Facebook group, go ahead and join. Do make sure that you answer all of the membership questions, because a lot of you have like pseudonyms on Facebook, which is perfectly fine, but I have no idea who you are. So please do that, otherwise you won't get accepted into the group. So we're going to sort of tag team, as I said, between Eric and myself for this, and then we're going to accept all your questions. So like normal, when we do these sessions, please drop all of your questions into the chat box, and then when we get to the Q&A part of the session, Pearl's going to call on you to ask those questions. So don't be afraid, there is no stupid question tonight, except for the one that you don't ask Eric and I. So here we go. So for those of you who couldn't quite hear what Pearl was saying, here is my bio. Ta-da! It is pretty much copied and pasted from my LinkedIn profile, so you can go to my LinkedIn profile and see all of it as well. But you'll see that my journey to the Canadian bar has been a long one. The plan was actually never to come to Canada, which I'm sure was the case for many of you on this session as well. You know, circumstances change and we move jurisdictions. So you'll see I've kind of gone a long-winded way to get here. And here's Eric's in his shortened form.
Yeah, well, I just highlight the key academic credentials, right? So my law degree came from the University of Leicester. I did a master's degree as well. Then I came back to Canada, finished my NCAs by May, and then I started practicing with the same firm I articled with Kashishan Law. And then I got called to the Law Society of Ontario in 2019, and I've been practicing with the same firm since then.
Fantastic. So you'll see you're going to get two different perspectives. You're going to get a BC perspective and an Ontario perspective tonight. So you're going to see a few little differences, but also probably quite a lot of similarities as well as we go through it. So we're going to take tonight in 3 stages. We're going to go through the stages of an M&A deal. And then Eric's going to give you a bit more of an in-depth look at one form of definitive agreement, which is the asset purchase agreement. And then we're going to get to an FAQ and Q&A section for you guys. So here we are. This is the stages of a typical mergers and acquisitions transaction. We've broken it down into 8 different stages. That's fairly typical for what we do. And so we're going to go through each of those stages in order. Hopefully that kind of makes sense for everybody. So we're going to start off with our preliminary discussions. Now, the preliminary discussions usually don't have the lawyers involved. Instead, it's the discussions between the sellers and the buyers, and maybe some third parties who've been involved in introducing those parties to each other. So at that stage, they're not really worried about what the deal structure is going to look like in terms of the legal deal structure. It's more about the business operation structure and what it is they're acquiring, which bits they maybe don't want to acquire. And so that's kind of what goes on in stage 1. Also to see if the deal is actually viable. Like, is it a good deal for the purchaser? Is it a good deal for the seller, depending on who's initiating the transaction? Then we go on to executing a non-disclosure agreement. Now, the reason we have NDA agreements is because as you're evaluating whether the target is a good target, you're going to be providing an awful lot of confidential information about the businesses on both sides, on both the buyer side and the seller side. And so by putting an NDA in place, it stops them from potentially releasing that information to other parties. It also can be used to prevent the parties from negotiating with other parties at the same time, depending on the various different clauses that you put into an NDA. Now, if you have seasoned clients who do this kind of deal quite regularly, they may have a standard form NDA in place, in which case they may not bring the lawyers in at this stage either. They may just roll out their NDA that they keep using. However, at this stage, most companies will bring in their lawyers to either draft an NDA or review the NDA from the other parties to make sure that they're not giving away too much. And by giving away, I mean giving away the information too much. Or they're also, it's so tight that you can't actually assess whether the deal is a good deal or not because you're not actually showing enough information. Then we get into the fun part, the letter of intent and the term sheet. Now, a term sheet sets out from the business's point of view what the most important elements of the transaction are. Now, these are not necessarily the legal elements of the transaction, but they're what the business feels are the key terms that need to be brought into the transaction documents as we're going forward. Quite often, term sheets also don't involve lawyers. The parties will draft them up themselves based on what they think is key to the deal. However, when you translate a term sheet into a letter of intent, that's often when you suddenly start to bring the lawyers in. So the clients suddenly turn around to their counsel and they're like, hey, I've got this deal. This is what I want to do. Here's my important terms. And the lawyer's like, okay, but what about this and this and this? And that's where you start to pad it out a little bit in the letter of intent. That will usually be done by the relationship partner for the client or whoever is the lead on the transaction. So as a junior, you'll probably review it, but you probably won't be drafting that part of it. Then we get into the pre-signing period and the due diligence period. Now this is where it's really heavy on articling students, summer students, junior associates. This is where you guys can go crazy and be involved on deals because it's time intensive, manpower intensive. And that's because there's a number of different factors when we go into the due diligence period. So increasingly, we're looking at the regulations, competition regulation, antitrust regulation, anti-bribery laws, looking at international ramifications. We're looking at potential tax consequences. We're looking at risks and liabilities for the business. So there's lots and lots of different elements that we're taking into consideration during the due diligence period. And so what will happen is quite often the buyers and the sellers will put together a due diligence request list. And they're all more or less the same, but they all have different layouts. They all have different wording. And some of them can be 60 pages long, and some of them can be 2 pages long. And the size of your due diligence request list is almost reflective of the level of complexity of the transaction and the type of business that's involved in the transaction. So you need to think really carefully if you're being asked to put together a due diligence request list, because that's very common that an articling student or an junior associate will be asked to prepare that, because it's a fairly standard form document, and then you'll tweak it to fit the deal. So you'll be reviewing back to your term sheet and to any other information that the client's given you, and making sure that all of those key points are covered in the due diligence. So you're looking for liabilities, obligations, material contracts, key employees, assets, financial statements, any kind of regulatory compliance that may exist. So for example, if it's to do with a mining asset, you're going to have all sorts of like the mining tenures, the work obligations that you have to do on a mining tenure, if there's any environmental issues. If you're buying, say you're a purchaser, you're acting for the purchaser, what are you physically buying? Are you buying a building? Are you buying intellectual property? Are you buying knowledge and know-how? So you need to make sure that you cover all of those different bits within your due diligence request. And then on the flip side, if you're on the other side of the deal, you'll then be preparing the responses to those due diligence request lists. So it means you'll be gathering all of that information. And this is where you become a project manager, because you'll be going through it and you'll be asking the client, and sometimes they're third parties. So for example, their CFO, who may be a contractor to the business, their accountants, their auditors, various different other organizations, to get all of that information together to be able to create what we call a data room. And so then the data room is then accessed by all the relevant parties to the transaction, and then they can review that alongside your responses that you provide to the due diligence request list. So Eric, have you been involved in doing a DD list?
Yeah, but because we are a boutique law firm, a lot of our DD lists aren't quite expansive. Like the main things that we kind of have to review is if we're representing the purchaser, we have to make sure that whatever they're buying doesn't have any kind of liens or outstanding taxes on it, or any outstanding fees to the worker safety board or any kind of employees. So in terms of due diligence, those tend to be the main ones, unless the client requests some more thorough due diligence research on our part.
Absolutely. And it may be, yeah, and it may be that you don't have to do all the different steps, because the client may make the financial decision that it's not a big enough risk for them to warrant doing all of the due diligence requests. But you as a starting point should consider all of those different options and then discuss that with your client, work out what's most important to them. So
for sure.
Yeah.
Well, it also depends on the type of business. So what I find anyways is that if you're dealing with franchises, so McDonald's or Subway, one of the bigger chains, they pretty much will do most of the due diligence for the lawyers. And just when we get involvement, it's more just a signatory process. All the work is pretty much done. We just have to make sure the documents are in order and we send them off to the other side. And it just gets signed and stamped by the franchise.
Absolutely, and that's where your project management role comes in, because you're literally just the go-to person who coordinates the collection of all those documents and then the distribution of those documents. And you may do a cursory review of them just to make sure that there's nothing glaringly terrifying in them that the client should be aware of. But yeah, if you're doing something over and over again, such as franchises, then documentation is probably fairly similar for all of them. And so you know exactly which documents are the potential ones you need to review.
Yeah, it's funny. Even though we may hate big corporations at times, they do have nice templates when it comes to doing simple transactions. And so it does make the lawyer's life a lot easier dealing with certain companies as opposed to others.
Yeah, absolutely. And we've just done a transaction, or we're doing a transaction right now, which is an international one. We are it's in Australia, Singapore, and Canada. And there's 3 different companies involved. And it's actually all to do with IP on this one. So we're acquiring the businesses, so we acquire the IP. But we've been having to do all sorts of searches to make sure that the companies are in good standing in each of the different jurisdictions. So that's one thing, that because we have financing involved, the financing part of the transaction have requested certain due diligence documents, which we maybe wouldn't have done in the past, and we'd have just taken it on an undertaking from one of the parties that they are in good standing. But they were like, no, we actually want like corporate searches from each jurisdiction for each entity to show that they're in good standing and who everybody is on it and things. So it really, as you just say, Eric, it really comes down to the individual deal and what the requirements are on it.
Yeah, for sure.
So then we get into...
We'll be taking questions at the end of your presentation. Okay.
Yeah.
Okay.
Yeah. So then we get into the definitive agreement. So by this point, as we've been going through the due diligence period, there's been all sorts of discussions and negotiations going on where all the different parties have come to a decision of what is the best structure for this particular transaction. And it could be that it involves us doing a share purchase, which means that we buy the entire entity. So, and by doing that, we buy the shares of the company and we buy everything within the company. All the liabilities, all the obligations, all of the assets, everything. Or maybe we do it through an asset purchase, which is a little bit different. So I'm going to hand over to Eric, who's going to explain what an asset purchase is.
Thank you so much, Siobhan. So my discussion will be talking about asset purchase agreements. Do I have control of the slides?
I don't think so. Do you want me to?
Okay. Okay. All right. So yeah, so can you just click so we can get an overview of my topics? Thank you. So what I'll be reviewing is exactly what is an asset, and then I'll give you a general overview of what an asset purchase agreement is. And then we'll go into more details as to what exactly an asset purchase will include, like what elements, what types of provisions should be included. Can you click again? And then on top of that, when it comes down to buying or selling companies, there's additional forms that need to be included along with the asset purchase agreement. So I'll do a brief overview of what also gets included. So in terms of what an asset is, it can be either tangible or intangible. So when we say tangible, it means something you can physically hold in your hands. And when we say intangible, it means it doesn't actually exist, but on paper it exists. So for example, when we say tangible, it can refer to furniture, it can refer to buildings, it can be referring to cars, it can be referring to people. Intangible can be referring to things like intellectual property, trademarks, ownership, stocks, things that don't actually exist, but on paper they exist, but they hold value. So when you're looking at doing an asset purchase agreement, what exactly are you buying? So you have to be very clear as to what you're purchasing, and have an idea of, okay, this is what I want, this is what I'm going to pay for. And then when you start clicking, these are some of the assets, obviously, that you could be purchasing when it comes down to asset purchase agreements. Can you go to the next slide, please? So in my firm, we're a boutique. So we do a lot of deals with smaller companies. And so usually when we come into the picture, as has already been mentioned, is that the deal's already been reached. Both parties or multiple parties have already agreed on what they're buying, what the purchase price is going to be, and what assets are going to be exchanged. So it makes our job a lot easier. Essentially, when we get drawn into the picture, we just have to drop the agreements that our client would like us to draw up, and obviously the other side as well. So that's one of the positive aspects of asset purchase agreements with boutique law firms, is that usually we don't have to be involved with the negotiating side of it. Can you click? I think there's some lines. Yeah. Purchase price has been agreed. Yeah, so as I already kind of mentioned, purchase price has been agreed. They've already determined what assets are going to be purchased, and then they just want to finalize their transactions through a formalized document, which is where we come into the picture. Can we go to the next slide? So what exactly is included in the asset purchase agreement? So we have to make clear who the parties are involved. So vendors, purchasers, shareholders, landlords, those are all going to be the main components in asset purchase agreement. And so with vendors, what are you selling? Purchasers, what are you buying? Are the shareholders going to be involved? And because we deal with a lot of small businesses, there's always going to be landlord implications into it. So we have to make sure that the landlord is aware of what exactly is happening. Because usually within landlord agreements, there's a provision within them that states that when the company changes hands to another owner, the landlord will have to give consent in some form. So you always have to make sure you have to communicate this with the landlord, or someone has to. What's the total purchase price going to be? You have to be clear on that. Or else if you're off by a few dollars, or if there's last minute negotiations, that could potentially torpedo a deal. And it's happened in our firm, where they agreed to a purchase price, but because of delays, the purchaser wanted additional funds and the seller was unable to meet those expectations. And so the seller essentially just walked away from the deal. So you always have to be clear on the purchase price and make sure that these transactions are done in a relatively quick fashion. And in terms of payment, that's another big one. What we're seeing now is the way these payments are being structured. So usually when you enter into a deal, there's a letter of intent or there's a deposit that needs to be made that would demonstrate that the purchaser is committed to following through on the agreement. And so the way these deposits tend to work is that before the asset purchase agreement is actually entered into, they pay a deposit of whatever it is, 5, 10, 15,000, depending on what the purchase price is going to be. And then the remaining balance is due upon the closing of the documents. Or in some cases, they can spread the purchase price over the course of the years. It really comes down to what the parties would want and expect. And then, as I already kind of mentioned, is what assets are being bought. You know, is it just going to be furniture? Are you just going to be buying just tangible or intangible assets? So those have to be clearly stated in the purchase agreement. And I think there's one more point. Okay, no, there's not. So as I was kind of mentioning, the role of the landlord. This is extremely important for us, whether you're the purchaser or the vendor. Because you're dealing with businesses that are most likely leasing from a third party, or they have assets that they're renting from a third party, or they're on property that's owned by a third party, you always have to make sure that these leases can be transferred to the new purchaser. And so usually what ends up being is that you communicate to the landlord or the leaseor that there's going to be a change of ownership in the company. And you do that by simply just communicating with them. Usually you can check the agreements, and there should be a provision within these agreements that allow the transfer of ownership. But sometimes it's not. And so this is where you kind of have to communicate with the lease or the landlord if they're willing to transfer the assets. If they're not willing to transfer the lease or the assets, then this is something that both parties, the purchaser and the vendor, have to discuss as to how they can go about either transferring the lease or finding sufficient funds to satisfy the outstanding balance on the lease so that they can secure new equipment or secure new property. So specifically when it comes down to signing a lease in terms of the property itself. If you get the consent from the landlord, usually you have to look at how many years is the lease going to last. Is it going to be 5 years? Is it going to be 10 years? How much rent are you looking at? How much is the rent going to be increasing? And then a key factor is who are the guarantors? So usually when a company signs off on a lease, they're liable, but then the landlord will also ask as additional insurance as an individual guarantor to ensure that if the company doesn't fulfill their obligations on the lease, then there's at least a guarantor to safeguard that. And so usually they would want one of the directors. So one of the key things that we tend to recommend when it comes to guarantors is that the director only be listed as a guarantor for a period between 3 to 4 years. Because usually within that period, they should be able to demonstrate that they're a good, well-paying tenant and that they were adhering to the lease agreed upon between them and the landlords. And usually landlords are pretty good about that, but some landlords are not. And so you always have to demonstrate, you always have to communicate that with the client as to what their liabilities are. Because just because you sell a business doesn't mean you're completely, you're not that you're exempt from the requirements of the landlord. If you're still listed as the guarantor and there's defaults in rents, you can still be on the hook. And we've had cases of that we've personally had to deal with. So it's always, you always have to make sure that when you're looking at guarantees, you have to be very, very careful as to who's going to be the guarantor, how many years are they going to be a guarantor for. So just keep an eye on that. Is there one more point by any chance? Okay, next slide. Okay, so now we're getting to the asset purchase agreement itself. So what is it included? So we have to look at what the assets. So is it furniture? Is it buildings? You know, you have to be exactly clear what exactly is being bought. And then we have to look at the purchase price. How much is it going to be bought? What's the total purchase price? Is it 100,000? Is it 10? Is it 15? Whatever the amount is. And the structure of the payments. Because these payments need to be made by certain dates. And if it's not, then the other party can claim that there's a breach in the contract and potentially they can seek remedies. So you have to be sure that these payment structures are adhered to and that the clients are well aware of what the expectations are of these agreements. And the closing date. So when we say closing date, that means everything's finalized. All the documents are signed. All the paperwork has been cleared. It's been exchanged by both parties. Everyone's happy. And that the transfer of ownership of the property occurs between the vendor and the purchaser. I think that, right, there's a few more. Also within these, we have covenants and warranties. So promises, what are the promises between the parties that they agreed to? Warranties, if something goes wrong, does one party provide compensation to the other party? Employees, that's another big one. So usually when someone buys a company, they request that the vendor lay off the employees because the vendor will have to assume responsibility for any types of compensation, vacation pay, or severance pay. The purchaser usually doesn't want to assume those responsibilities. That's why they request the vendor to simply lay off everyone and they are responsible for it. Some cases it's not. Because obviously what happens is if the vendor doesn't lay off the employees and the purchaser assumes responsibility, then the purchaser is responsible for the severance and the vacation pay. So usually that's what I've kind of mentioned earlier, that it's up to the purchaser to temporarily lay off the employees and the purchaser will rehire who they want to without being restricted with previous liabilities. And then indemnity agreements. So in the event that certain things happen that damage the purchaser or in some cases the vendor, the other party can claim compensation. So you always have to make sure those indemnity clauses are clearly stated as to what compensation either party may be entitled to or what events would trigger indemnity clauses to begin with. So you have to keep a good eye on that because that's one of the key areas of litigation that arises. And then liens. So when you're buying assets, you have to make sure that you own the assets and it's not in possession of a third party. When we were talking earlier about due diligence, this is one of the things that we have to review, that whether or not these assets are owned by a third party or there's liens on them that would prevent our clients or potentially the other client from having sole possession of that. Because as you can imagine, if you buy something that you don't technically own, it can create potential issues. So you have to be aware of what liens are and then take care of them as soon as possible. And then, as we mentioned in terms of due diligence, Wsib payments and outstanding taxes. So Wsib, if you have employees in Ontario, I assume this is Canadian-wide as well, that you owe dues to the Worker Safety Board. So when you're buying a company, you just have to make sure that there's no outstanding payments owed by the company to the Wsib. And of course, any outstanding taxes to the CRA. It's always something you have to keep a good eye on. This is why you write certain letters to the CRA, and I believe they're called comfort letters, who will give you, who the CRA will do analysis on the corporation and determine whether or not they owe any kind of outstanding taxes. Because obviously if they do, then they have to take care of it. And it's better to get it done sooner rather than later. Can you go to the next slide?
All right, so this is kind of a joint one. So then we get into our pre-closing period. So this is the bit where we've probably signed up our definitive agreement, as Eric has been talking about, in whatever shape or form that definitive agreement is. And as Eric mentioned, we'll have a closing date. And the closing date might not necessarily be the same date that that document was signed. So the closing date will be the date that the whole transaction closes. So between the date of us signing the definitive agreement and then closing the whole transaction, we have what we call a pre-closing period. Now this is the bit where we do all of the ancillary documents that go alongside the definitive agreement. So we'll do all of the resolutions, whether they be shareholders resolutions, board resolutions, approving the transaction, and also approving entering into any other documents that are required to affect the transaction. It's also the period where we can go about getting those third-party consents that Eric talked about. If we have a public company, this is where we also have to do an awful lot of things in order to affect the transaction with the exchange and the commission's approval. Now the exchange can be whichever exchange the company is listed on, and also the commission will be whichever provincial commission the company is related to. So for the majority of the companies that I work with, we are with the BCSC, so the British Columbia Securities Commission. The exchanges that my clients work on are numerous and many. So we have to go to the various different exchanges, and they all have different rules and regulations about how we do transactions. And so there's various different steps that are involved. That would require a whole different session to talk about all of those different rules and regulations that are required. However, they're only required if your company is public. So some of those rules don't apply if you have a private company. So it's privately held rather than the stock being sold on the stock market, the shares being sold on the stock market. So there's various different steps that we have to do there. We've listed out a few of them. Remember, you are going to get these slides, so you don't need to note them all down. And then Eric has very kindly put together some additional forms that he uses.
Yeah, so along with the asset purchase agreement, there's other documentation that you need to include, at least we do. And I've generally seen with other law firms also include this. It's basically the same forms. So the bill of sale, it's a formal document that basically states what are you actually buying. List the purchase price, list the parties, both parties need to sign up on that. Certificate of authority and incumbents, basically the company that's buying the other company, they have to give documentation that they have authority to actually act on behalf of the company. Because you have to keep in mind that corporations and individuals are two different entities, and they're two different perspectives, right? So if someone is signing on behalf of a company, they have to demonstrate that they have the authority to do so. And so this is where this document comes into play, where they in writing state, yes, we have authority to act on behalf of the company. Direction of payment. So where's the money going to? Is it going directly to the client? Is it going directly to the law firm? Usually what happens is if we're acting as the vendor, we will receive the funds in our trust account, and then we disperse it to the client after we've taken our fees for the transaction. Director resolution, it's another formal document from the corporation itself that they are performing this transaction on behalf of the company. Because with corporations, there's certain rules you have to adhere to. So anything the company does, you have to document it in written form through resolutions. So the director will have to state, so-and-so on this date agreed that we are buying so-and-so company for this price. And so they have to formalize that in their own minute books. Full and final release, that you only use that if there's litigation that occurred in the course of the transaction. So let's say if one party sues another for whatever it is. Full and final release will ensure that there's a settlement in place and that both the parties have come to a resolution and that there will be no further litigation from that incident that already occurred. So you usually don't see those unless there's litigation involved. And then indemnity agreements. So I kind of mentioned that earlier, but there's a formal agreement whereby if a certain event happens, one party may result in providing compensation to another party, assuming that one party was injured. So an indemnity agreement will spell out exactly what those conditions are, how much compensation potentially could be, and what each party may be liable for.
Yeah, and the direction of payment doesn't have to be a cash payment. It can also be in the form of shares.
Oh yeah, that's a good point. Yeah, yeah, it's true. Because I don't do a lot with shares.
Yeah, so in the transaction, most of the deals that I do are typically a combination of cash and also shares. And so your direction of payment will set out how the shares are to be distributed, but also how the cash payments are to be done. And the direction of payment will also take into account, as Eric said, whether you're doing it in tranches. So sometimes there'll be certain milestones that will be triggered in order for the complete transaction to take place and the full transition to happen. And so it may be that, as Eric mentioned, you'll do it in a sort of a rollout, a dribble out process. So you won't necessarily get all of the payment up front. So it's kind of like if you've seen right now, if you've been purchasing anything online, it used to be that you would pay for everything up front, but now you can do an almost layaway and you can pay for it in pieces. You know, you can break it down into payments of like 4 installments or things like that. And often we'll do that on high value transactions. And so the direction of payment will set that out, and that will also be included in the definitive agreement as well. And it's usually mirrored in the resolutions that Eric mentioned as well.
And then statement of adjustments. So it lays out exactly how much money is owed, what has already been paid. So typically with our transactions, there's a deposit. So on the statement of adjustments, you have the purchase price, you have what's already been paid, and then what's outstanding that needs to be paid. So it just gives a direction for all the parties as to what's already been paid and what needs to be paid. Sometimes it includes dates, depending on how structured it is, but usually it's pretty basic in terms of what's already been paid, what needs to be paid.
Yeah, I mean, if any of you have done a real estate module whilst you're at law school, you've probably come across a statement of adjustment there because it takes into account things like mortgages and loans that exist on the property. And so there may be outstanding payments that need to be paid for the mortgage, for example, of the seller, of the vendor. And then that can be factored into the statement of adjustment of how the funds are going to flow on that one. Ooh, jumping ahead. So then we get into closing. Okay, now closing used to be something really sexy, right? We used to get all the different parties around a massive board table. People would fly in from all different places, and it would be your job as the articling student to make sure that every single document was printed in triplicate. It had sexy colored tabs, and those tabs were all color coordinated, so each party knew exactly where they had to sign, and they'd all be laid out across this boardroom table. And it would be you and your assistants and your paralegals just running around. The partner would just sit there basically whining and dining all of these parties around the table. However, now closing is typically done virtually. We do it through our computers, we do it on the phone. and we never sit around a boardroom table anymore. So gone is the big closing dinner that used to be the biggest highlight of a deal, because you'd all get to go to some fancy restaurant and drink wine and things. But now what we do is we do it virtually. We do it quite often with electronic signatures. There are some documents and some provinces and territories that still require original signatures for certain parts of transactions, typically in corporations, real estate in Ontario. They haven't quite caught on to electronic signatures quite yet, at least in my experience. So what you end up doing is you end up getting all the documents signed, having to pull them all together and getting all the different parties. So you're literally sitting there with the PDF software and inserting all of the signature pages electronically. And then you hold all of the documents in escrow, subject to all of the documents being present, all of the closing conditions being met, and then it's your job to then go through and electronically date all of those documents once all the parties have signed off, at least in my experience. Might not be your experience, Eric, because you deal with actual intangible goods.
Well, it's more personal for sure, because we get the client to come to an office, they sign everything, and then once our client has signed everything, we carry those documents off to the other counsel, and then they do the same, and then that's pretty much it, right?
Yeah. And I think it really comes down to whether your clients are local or not, and whether the other parties are local. My clients, for those of you who weren't here when we were just chatting at the beginning, my clients are dotted all around the world. So it's a lot harder to get them physically into the office and signing documents. So we kind of tend to do it electronically. But that's the time when everything is signed off. So all of those documents that you've been preparing, all the ancillary documents, all the third-party consents you've been getting, any conditions that need to be met, which are a condition of closing. So you need to have evidence that all of those conditions have been met, whatever those conditions may be. So it may be discharging a mortgage or discharging a lien on a property or an asset. It may be that you need to do some filings and bring some filings up to date. It may be that we need consent from the exchange or the commission, which if you are a public company, you do need consent from them prior to closing the transaction. So like I have right now for one of my clients, we're good to go, but we don't have consent from the exchange or commission yet. So we're all just sitting here, twiddling our fingers, drumming our fingers on the table, waiting. And then once they give us the consent from them that we can do this transaction, then we can finalize everything and issue the news release. And then we go into post-closing. And so for post-closing, there's a few different things you need to do. Now, this is for public companies. Okay, so this might not be the same if you're dealing with private companies, but at least for what I typically do, there are post-closing filings that you need to do with the exchange and the commission, including potentially a material change report. You'll do a news release on closing the transaction. There'll be CDAR and SETI filings that you need to do, and there's various different documents that you need to file and profiles that need updating. And then you'll also need to update the corporate records. So for example, if you've done a business sale, so you've done a share sale, and you've changed who the board of directors are, you'll need to do the various different corporate filings to update the new register of directors and potentially officers. And maybe you're moving where the minute book is held, because now it's, you've moved who the owner is of the company. So maybe you're also moving where the registered and records office is for the company. So then you'll need to do those kinds of filings as well. So there's corporate law, securities law involved. And then there's also all of the business post-closing things that will need to be done by the business, which probably don't necessarily require the lawyers to be involved, but there'll be things like doing consolidated accounts potentially for the businesses as you roll one business into another. You might need to do onboarding of your new employees. There'll be new payroll, PAYE, that you need to do, and all the different bits that go along with that as well. So that will be done on the business side rather than the lawyer side, but it's just things to be aware of. And if you have a relatively unseasoned client, you might need to kind of give them a heads up about those various different bits they need to do. All right, now we get into the fun part, Pearl.
Yes.
Q&A. So we came up with a couple of questions before we go into everyone's questions, because Eric and I are pretty certain that there's a lot of questions from you guys. So we took a few questions that we've been sent ahead of time, and we kind of cobbled together a few answers that we're going to add to. And then that way, Pearl, you can come up with like the order you want to go through the questions for everyone else. So if you do have questions, stick them in the chat box so that Pearl can get them in the order. But Eric, I'm going to ask you, what do you do in a typical day as an M&A lawyer?
So I have a general practice firm, so we do a little bit of everything. So although our practice is basically composed of solicitor side of commercial transactions, a lot of my other 40% of my workload is litigation work. So I split between the two depending on the workload of the day. So we have quite a few small claims files involving contract breaches. We have a personal injury matter that I'm dealing with. We're working on some immigration visas at the moment. I also work as a legal counsel for an eyeglass company, I-20/20 Vision, and they're in some heavy litigation claims involving breaches of contract. So my day is a bit varied depending on the workload. And then obviously if last minute things need to be done, then I have to adjust accordingly. So for example, yesterday, one of my clients was noted in default on a small claims matter. So right now I'm working on a motion to set that notice of default aside based upon a variety of reasons that I have now researched into. So it really depends. It's not as structured in a general practice firm as others probably would have experienced, but it all depends on what you want to get out of it. So I get a little bit of everything every week, it looks like, and I learn new things every day. So that's technically how my day kind of is structured.
Fantastic. Mine's a little different because I am a straight corporate commercial securities lawyer. So I don't touch litigation. Don't know anything about it. Please don't ask me. I have to call in the big guns to like help with that kind of thing. I also don't really do private client work. So nearly all of my clients, I would say 98% of my clients are public companies or they're going public. So my day typically starts at 5:30 in the morning, 6 o'clock in the morning, when the market opens. So as soon as the market's open, my clients are awake. And when I talk about the market, I'm typically talking about the TSX, so the Toronto Stock Exchange, the Venture Exchange, which is like the level down from the TSX, the NEX. Obviously, you know, we have the US Stock Exchange, the European Stock Exchange, because we have clients who are listed on all of those as well. So the morning is spent, at least the beginning part of the morning, with very reactionary as to what's happening in the market. So it's a lot of emails, a lot of phone calls. Then the bulk of my morning is then spent preparing documents, reviewing email correspondence, getting documents out. And then the market closes. And then we're super busy getting things listed, filed. So not listed on the exchange, but filed onto various different portals, because some things need to be filed during market hours. Some need to be filed post market hours. And the reason for that is if you file certain things during market hours and you put them in the public domain, then are you giving that information to just a small portion of the public, or are you ensuring that it goes to everybody in the public? And the concern there is, are you giving insider preferential treatment to a certain group of people rather than everybody? And could that then impact what the company is able to do and its stock price, basically? So that depends on when you actually tell the public what's going on with various different things. And then my evening is then spent with my heavy drafting. So my late afternoon, early evening, late evening is heavy, heavy drafting, because that's when the telephone typically goes quiet, the emails slow down, and I can actually just sit and concentrate and focus on what I'm doing. So that's kind of my day. I do a lot of telephone calls. as my husband will attest to now that we're working from home. He still can't get over how much I spend on the phone. And there's a lot of email traffic. And the email traffic typically increases, or at least I found, with the more experience and the more responsibility you get, because people will be coming to you directly rather than it all going through a senior associate or the partner on the file and then filtering down the information to you that they believe is relevant to whatever part of the transaction that you're doing. So we'll go into that in a little bit. So we've kind of talked a little bit about who we work with, kind of through that process and through earlier on as well, where the senior partner is typically the lead on the file. They manage the workflow, and they're normally the key contact with the C-suite, the decision makers of the client for you. And then the associates and the junior partners, they're the ones who are doing basically everything else, let's be honest. Like, they're doing the project management, they're doing the drafting, they're making sure that everything's being done on time, they're keeping track of the transaction. And then the more junior you go down, you're given specific roles to do and specific functions. And there's no rhyme or reason as to which bit you get, other than it's how much experience you've had and your willingness and desire to do things, or at least that's been my experience at any rate. It really comes down to, like, the more you want to be involved, people will see that and they'll give you more opportunities to be involved. But you'll tend to start with the smaller, often less complex documents that can be siloed out as one piece, rather than maybe you're probably unlikely to be asked to draft a definitive agreement on day one. Let's put it that way. That's something you build up to. However, doing directors' resolutions, they are 100% the kind of things you're going to be doing, because you have to understand the deal and then simplify it down in a way that, like Eric mentioned, that's a record for the company minute book as to what the main points of the deal are. So hopefully that makes sense on that one. And then as part of the project management role, you'll be dealing with the client. You'll be dealing with various different people at the client. So you might not be dealing with the ultimate decision maker, so the CEO or the chairman of the board, but you might be dealing with various different individuals. So the HR manager, if there's employment issues on the transaction, or maybe you're dealing with a property manager if you're dealing with property transactions, because they're the people who have the information for you to be able to gather that information for the due diligence process. And then you'll be dealing with the accountants because you'll need to get the financial statements and various things like that. So anyone I've missed off, Eric? Do you deal with anyone I haven't included?
Well, because I think my practice is slightly different because I'm more litigation based and more boutique. So when I started working with that firm, there was only one other lawyer and we had a part-time legal assistant. So I had a lot of hands-on experiences with everything we did. It just so happened at that point, we were more litigation based. So at least three times a week, I found myself going to court to file documents or just attend basic hearings on behalf of the client. And then in terms of drafting agreements, I didn't really do a lot with drafting initially. That came later. I was dealing a lot more with just drafting motion records, statements of claims, statements of defense. So when you are in litigation, you either are the plaintiff, defendant, or applicant respondent. And so if you are filing the claim, that means you have to set forth what exactly you want and what damages you have. And if you're defending, then you have to state why you should be responsible for any of the allegations raised by the other side. So I was doing quite a bit of that. And then I branched into the solicitor side of things. So my principal lawyer would show me, okay, this is our lease agreement that we have to review. These are the things you need to look into. And then we have to make modifications as accordingly. And then with asset purchase agreements, we'd work on that together. So I would do a rough draft of it based upon the recommendations that my lawyer suggested. And then he'd review my work. And then when he was happy with it, he would send it off to opposing counsel, and then we continued the deal from there. So it all depends on the size of your firm and what areas of law they practice in. So that'll basically determine as to how much responsibility you get. Because with smaller firms, you probably will get more responsibilities, but it's a different type of transaction as opposed to Siobhan's experiences in a more public law firm, right?
True. I'm also in a boutique, so I do a lot of the basic stuff too. I do all of my own corporate filings. I do all of my own searches and things like that as well. So I think it really does come down to the practice that you're in and the firm that you're with, as to what your exposure is. But you will get to do probably the smaller things to begin with, and then as you become more experienced, you'll build up, which I think Eric has shown as well. All right, we're going to hand over to Pearl for questions.
Well, can I just add one more thing, actually, before Pearl gets into it?
Yeah.
So, although we do a little bit of everything, I don't know everything, and that's okay. And so one of the things that you have to be crafty about is learning how to research how to solve different problems and use the resources at your disposal. So for when it comes to litigation, honestly, one of your best resources is the court clerk staff, because they'll tell you what forms you need to sign, how you need to sign it. And if you have good relationship with them, they'll tell you this information. They've helped me out a bunch of times. Like, for example, our client asked us to remove a lien on one of his properties. I had no idea how to do it. Fortunately, the court clerk staff pointed out to me what I need to do, what forms, how to get these documents, and they just laid it out for me and just made it very easy for me to do this transaction, and we were able to do it. So be sure to use your resources to the best of your abilities, and be nice to everybody. Like everybody, you'll never know who you see, and they talk. It doesn't matter if you're in a big city, small city. Lawyers, paralegals, admin assistants, court clerk staff, they all know somebody. So you have to treat everybody with respect, because you don't want to be that person that no one wants to deal with. Because there will be times when you need help, and if you're that person, it just makes your life more difficult.
Absolutely.
Thank you, Eric, and thanks, Siobhan, for the presentation. So I'm moving on now to questions. The first question was from Anjali, and she asked us, how are the checks performed? Do you write to CRA or Wsib to ensure there is no amount due? And how do you check liens? So I'm guessing this is in regards to the due diligence that Siobhan was talking about.
Yeah, Eric, you go for it, because you do this more than I do.
Yeah, okay. Oh, I do it occasionally. So CRA, I can't remember the exact number, but you basically write a letter. It's called a comfort letter, and you have to have certain requirements in it to the effect of, I want to review the tax records of this corporation. Oh no, my apologies. I'm confusing things. So if I'm a lawyer for the vendor, I have to obtain the comfort letter on behalf of my client to demonstrate that there's no outstanding taxes. So you need to have a consent form from the client that lets you have access to these tax records. So there's a form you fill out, I can't remember the exact name of it, and then you include it in this letter stating that you want to have a review of the HSD accounts of this particular entity to determine whether or not there's any outstanding liabilities. And it's the same process for the WSIB. There's a form you need to fill out to demonstrate that you can act on behalf of your client and gain access to these accounts, and then you write a letter stating, I'd like to have clarification if the client has any outstanding dues owed to the WSIB.
Yeah, and there's also third parties you can use, so you don't have to do those searches yourself. There's organizations, companies that you can use who will undertake all of that for you, which is especially useful if you're doing searches in a different province or territory to where you're based, because they will have somebody locally who can do it. Because, for example, if you need to do searches to do with potential litigation cases, so you're doing a litigation search, particularly if you're in Ontario, there are many, many different levels of court and all the different counties and regions and things like that. And being here in BC, I thought it was relatively simple. And for those of you who are in BC, we only have 3 places we have to search. But in Ontario, there's almost hundreds of them that you have to search. And so you have to pick out which ones are relevant. And so we've always found, at least at my firm, that the third parties are the most useful and the most effective for our time and cost for the client to use them. And so you'll just get the client to sign a fairly standard form that they have that authorizes them to do searches on the behalf and then give the results of those searches to us as the lawyers to then use for them. So hopefully that answers your question.
Yeah, exactly.
Okay, so the next question is also from Anjali, and she said, is there a difference between M&A deals for private and public companies? Are lenders or creditors like banks, are lenders, creditors like banks a party to the M&A deal?
Good question. Lenders and creditors, they can be. It depends. They end up being like a third party often into it. Depends on how the deal is structured. If the deal is 100% based on needing debt financing, then yes, they will be heavily involved. Their legal counsel will be involved, and there'll be their own due diligence that they need and various different things. But if it's just a matter that there's a bank, that if there's an asset that happens to have a loan or a mortgage in place, then there'll be a third party. There'll be a much smaller part of the transaction because it'll just be getting authority from them to discharge that loan or mortgage. And there'll be some steps that have to go through.
Yeah, exactly. For us, when it comes to mortgages, lenders tend to want to receive full payment in order for the transaction to proceed. That's the experience we have. They generally don't want to change the mortgage from one company to another company. It just gets too messy and complicated. So they usually just want that mortgage to be fully satisfied in order for the transaction to proceed.
Yeah, and it may be a term of the transaction. So if you're acting for the purchaser, it may be that you actually need to have financing on those assets. So for example, if you're buying a trucking company and there's currently a bunch of loans on the various different trucks, the bank who holds those current loans will be like, yeah, we need to discharge those in full, i.e. you need to pay them off in full. However, the purchaser may turn around and go, yeah, but I can't do that with cash, so I need to have like my own loan for those, in which case then you'll be discharging the loan and putting a new loan on there. So there's different ways depending on what the deal is and how you're structuring the deal.
Yeah.
On that one. And the difference between private and public is that public, there's just more requirements. There's more steps you have to go through. There's more consents that you need from the exchange, from the commission. There's various different filings that you have to do in addition to the corporate filings that you may have to do. In the presentation we've got, there is a list of various different places you can go for those rules and regulations. I haven't put them for every province, I'm afraid. I just put them for the provinces that I deal with, which is typically BC, but you can use your favorite search engine, such as Google, and you can look up the equivalent in whichever province or territory you're based in to see the individual rules. But it does set them all out for you on that one.
Okay, so Beatrice asked, is there any kind of additional pre-qualification required to practice this area of law?
So in terms of what, entering commercial law, I'm not really. It's just depending on which law firm you get into will determine what laws you kind of practice. It's always good to have kind of a business background so you're familiar with the terminology, but there's no like prerequisite qualification that you need to do commercial law. You just need to be open-minded and be willing to learn new things and new terminology, and just be willing to adapt yourself accordingly. That's been my experience anyways.
Yeah, you just need to be qualified in the province or territory that you're working in. You know, ideally, if you're doing an M&A transaction and it involves, for example, we did one for a client where my client is based here in BC, but we bought businesses in Ontario and Saskatchewan. We actually engaged local counsel in Ontario and Saskatchewan to do parts of the transaction. So they have a better knowledge of the local corporate laws that are involved, and particularly on this particular transaction, there was property involved, so real estate involved, and they had a much better idea of all of the local provisions around that. So they handled those elements for it, and then we did the rest of the transaction, bringing those in. The same with the deal I'm doing right now. We have Singapore and Australian counsel involved because we have to do what they call a bidder statement in Australia. And because it's a public company in Australia, they're listed on the Australian Stock Exchange. My client's listed here in Canada, and then the other party is a private company. So we have local counsel in Australia, and then we also have local counsel in Singapore because there's a sub company in Singapore. So just to be really, really complicated on that one. But in terms of general skills that might be useful if you wanted to go into corporate commercial M&A work, drafting, negotiation are integral to M&A practices and fundamental skills. A willingness to learn, as Eric said, an aptitude for project management, because you are going to be doing a lot of collating and distributing of various different information. So being aware of deadlines, time management, things like that is very handy. And then having a general capacity to understand your client's business needs and goals generally, but also for that transaction. And that's something that you might not know straight away, especially as a junior if this is the first time you've ever met that client, but that's something that you'll develop over time that comes with it.
Yeah, experience everything else, and then just developing a relationship with the client in order to determine what exactly their needs are, and then doing your best you can to meet those expectations. So yeah, client relationship skills, interpersonal skills, because you're going to be dealing with all sorts of people, people with academic backgrounds, people with non-academic backgrounds, people with different walks of life. So just understanding what exactly they want from you and helping them towards their objective. That's really one of the key things, I think.
Okay, so this question is for Eric. Is the deposit paid to and held by an escrow agent?
Okay, I think I kind of know what you're asking. So in our case, usually the deposit is held in a trust account by either our lawyer or opposing counsel. And then once the transaction has concluded, then the deposit gets dispersed to whoever is entitled to receive it. So that's generally how we do it. I've never used an escrow agent, so I wouldn't be quite sure how that process works. This is usually why law firms have trust accounts that are designed to hold these sums of money and then dispersed and once certain conditions have been satisfied.
Okay.
I have a client currently where we're using an escrow agent. We typically try and avoid them because there's an additional cost and administrative matters that are required. So unless the deal structure requires it, we typically don't do it. We'll do something similar to Eric. But for this particular deal, we are, because we did a round of what we call subscription receipt financing. Mm-hmm. And so all of those funds are being held by, so this is all external subscribers to the company, have basically all put forward money to become shareholders in the ultimate public company once the transaction is done. But there is probably a 3 to 4 month gap between them subscribing and then the deal actually finalizing. And so those funds, the brokers have all asked as part of their conditions for organizing all of that money for it to be held by an escrow agent, and then they will release it on certain conditions being met. But it's typically used on much larger transactions rather than on the smaller ones because of the cost and additional admin involved on them.
Okay. So Anjali asked, are the assets valued by a CPA?
Yeah, well, it depends. So for our smaller transactions, assets themselves aren't as valuable as you think they are. It's mostly the business itself. What does the business generate? So when we start looking at furnaces and cars of that nature, it's negligible in terms of the actual value of the business itself. So yeah, in certain cases, you can use a CPA to determine the true cost. like buildings and things like that, this is where we use CPA, or we get an assessor and appraiser to determine what the actual property value is. But it really depends on the business size itself. But usually the parties themselves agreed beforehand what should be bought at what price.
And then for my clients on a public deal, you have to be able to evidence what the value is. So you have to have supporting material for whatever value you determine the business or the assets to be. Now, that could be a CPA, it could be an external valuator that you bring in, or it could be determined through the due diligence process through the board of directors. So it really, as Eric says, it really does determine what it is you're purchasing and the value that's involved. It is something that the exchange has been asking a lot more recently, is how was the value determined? And can you evidence how you came up with that number? Particularly when you're buying what we call shell companies. So there are no tangible or even intangible assets. It's just an incorporated company that's sitting there that's not really done very much. So how are we giving something that hasn't produced anything or done anything a value? And especially quite often when those values are quite high. So that's when there are mechanisms that you can bring in, and there's various different formulas that you can use for doing that as well.
Okay. So Maria asked, when you need the consent of a third party, when within the transaction cycle is the appropriate time to approach and communicate with the third party about the transaction and secure the consent?
As soon as possible. Just do it. The moment you are required to do so, just do it. Because things can get delayed and transactions get delayed. Costs increase. Parties aren't happy because something's holding up the transaction. So if you need to get a consent from a third party, just do it as soon as possible. It's the best advice I can give.
Yeah, typically around when you have a term sheet, letter of intent, and probably an NDA in place, if you're putting an NDA in place, just because then both parties have made a conscious decision to move forward with the transaction. And so at that point, everybody's bought into what's going forward. You don't want to get them when it's just an idea and then the deal isn't actually going to happen because it was literally just an idea thrown on the back of a napkin. But yeah, as early as possible.
Okay. So Heather is asking, if you are, for example, purchasing an asset outside of Canada, or you are representing a client outside of Canada, at what stage do you engage with local counsel, if at all? How often do you work with external counsel?
I've never dealt with external counsel. I know my principal lawyer has done a few transactions. So usually we only will hire external counsel when there's a deal in place, deposit's been paid, and all parties involved are aware that external counsel is needed for this transaction to go forward. And so we've already received the necessary funds to contract a third-party counsel in order to purchase the assets that are applied to this transaction. That's the general approach that I was told that we would pursue if we were to go down that road.
Similar for us, because my clients are based all around the world, we might engage them a little bit sooner, because typically my clients will have a subsidiary company based in one of those jurisdictions. And so we will at least notify local counsel there that we're doing a transaction and that various different things will be needed, because some jurisdictions are a little bit slower than others to be able to turn things around. So we'll give them a heads up that things are happening. But for example, one of the deals I'm doing right now, the Australia-Singapore BC transaction we're doing, we had external counsel from almost immediately, because the main asset that we were purchasing is an Australian business. So we had them on deck from day one.
Okay, so Joad is asking, when doing due diligence and determining what a company's litigation exposure is, can lawyers carry out separate and independent checks to see whether the company is embroiled in litigation or pre-litigation processes, ADR processes that the company has not disclosed?
So with Well, it depends. So you can only really determine litigation claims if it's been filed in court. If it's ADR, those tend to be a little more difficult unless you kind of know someone involved in those kind of disputes. You'd have to have firsthand knowledge. So you can do background checks. So what we do is we go to the courthouse. They have a special computer that lets you do research on different corporate entities to determine whether or not they're engaged in formal litigation. So that's kind of how we can do the due diligence. But if it hasn't entered the litigation stage, if they're doing ADR or arbitration, it's very difficult to find that out unless you kind of have firsthand knowledge that they've been participating in. But this is kind of why you have those release agreements where you can specify, okay, have you fully disclosed all potential litigation issues? Because if you haven't, then the transaction can potentially be voided. This is why you have to be open and transparent when these disclosures need to be made.
Yeah, because you'll be putting reps and warranties into your documentation. Yeah. And so for anyone who's done any sort of contract drafting, you'll have your reps and warranties. And if you breach any of those reps and warranties, you know, one of the outcomes is that you can void the entire transaction. And then there can be like monetary obligations and all sorts of things that are then imposed. You can also do searches on the individual directors and officers as well as doing it on the corporate entities. So sometimes that can be useful because it may be that a director or an officer has been personally involved in a litigation case. And in terms of whether you do them yourself or whether you rely on what's being disclosed to you, that is kind of up to the client to make that decision. If they feel that during the discussions that they've been having, which are often done without the lawyers present, but if they feel there might be something there, then it's probably advisable to do them yourself and confirm. But in the due diligence process, one of the things you're often asked to provide is a list, which is got from your searches that you've done. And then you can make additional inquiries as to like how relevant they are. Because it may be that you're just a named party, but you're actually just fourth down the line and they just named everybody they could think of, but you're actually not the main party to the litigation case, for example. Litigators will understand that more, but hopefully that kind of makes sense.
So Jawad is asking, what if some litigation is found post facto after the transaction is completed? Are there typical indemnity clauses?
Yeah, that's kind of the idea behind indemnity clauses or warranties and confidence, right? Where if one party didn't disclose that they're involved in litigation issues, then this is where the indemnity clauses kind of kick in, where they then have to compensate the injured party. So this is why you have to make sure you have good indemnity clauses that would safeguard the interests of your client. So if there is litigation that's discovered after the transaction has concluded, then you can at least safeguard your client's interests.
And there'll also be a period between your signing your definitive agreement and then the closing of the transaction. And during that period, just before you do the actual official close of the transaction, there's often what we call a due diligence call, which is where all the parties will get onto a phone call with their lawyers, with their CFOs, with their accountants, with their auditors, and they'll actually run through the checklist and notify each other if there's been any changes since the due diligence response was provided. And that's another check to see if there's anything, almost like a subsequent event when we did accounting and when we looked at the financial statements, if anything has come up in between that period of time. And that way then you've had the opportunity to notify and be aware of what's going on.
Okay. So Namarata just asked a question. She's saying, how do you ensure that the closing date doesn't indefinitely keep extending?
That's a tricky one. That's a tricky one. Siobhan, do you want to answer?
Yeah, normally you have a drop dead date, and then it can be subject to change by written agreement of all parties. And there's normally a period of flexibility where, if all parties are pushing and it's just because something is being held up, like the exchange is taking a little bit longer to come back with their response and their approval on a transaction, then maybe everyone will agree to it and you'll do an extension to your definitive agreement or an amendment to your definitive agreement, which will have an extension to your closing date in it. But normally all parties will say, well, at some point we're going to have a drop dead date, but bearing in mind all of the costs that have gone into getting to that point, it's always a business decision as to how long they'll keep going before they say, you know what, enough's enough, we're going to walk away from this deal, because there's still all those legal costs and all those other ancillary costs that you've incurred. And at this point, you know, it really is down to the clients as to what they feel they're comfortable with.
Yeah, exactly, Siobhan. You hit the nail on the head. What exactly are the clients prepared to absorb in costs if this closing date becomes a moving target? For us, that's one of the issues that drives these transactions to close, because one party doesn't want to assume the lease payments, rent payments, paying their employees beyond a certain point. So this is what kind of forces both the parties to get the transaction done as soon as possible. You don't want to be paying for things that you don't want to be paying for.
And I think also now we've gone away from the style of negotiating in transactions where it was very sort of, what's the word I'm looking for? Where we were like very angry and butt heads, and I can't think what the word is, but now it's much more of a collaboration. I can't think of what the word is, but you all know what I'm talking about. Anyway, we used to be very aggressive in, or it used to, not me personally, but the world used to be quite a lot more aggressive in terms of their approach to transactions. Whereas now, at least for my clients, they all want to get the deal done.
Yeah.
So we're working collaboratively to achieve that end goal. And if we slip by a couple of days or we slip by a month, people would rather accommodate that in order that we can get the deal over the line happening, rather than actually terminate it. Because actually unraveling a transaction, especially if it's a public deal or a very complex private deal, can cost even more money than just waiting 2 months and then closing.
Yeah, that's the same experience for us. Like once you get involved in these, very rarely does the transaction terminate due to a closing date that keeps getting postponed. Usually if they've put this much time and resource and money into the transaction, they'll find a way to close it unless something happens where it just doesn't make sense to continue on.
Yeah.
So I'm just wondering, with the COVID situation, have you had any deals that have had to terminate, or you had to find, you know, another way to work around it, or have it delayed? Have you had that experience?
Yeah, I had one transaction. It was a bakery shop in Riedel Mall, strangely enough, that there was a buyer for it, but they kept dragging their feet for whatever reason. And then ultimately our client just said, you know what, it doesn't make sense. This person doesn't seem serious. Let's terminate the transaction. And we had pretty much had all the documents set in place. We just didn't receive the funds from the other side to complete the transaction. And they just kept trying to negotiate a lower fee due to COVID, or at least that's what they claimed it to be. And so we ultimately had to terminate that transaction.
Okay. And then I have one more question. With all the deadlines and all the consent you need to get, how do you stay on top of it so that you don't miss deadlines? Do you have a special bring forward system, or you need to have a super paralegal to make sure everything is, you know, right on time?
Yeah, so I mean, for me at least, and this is the way I've always been trained and was even trained in the UK, was you'll have your closing steps. So you'll actually have a document which is like an index, but it sets out every single step. And in that, it will list every single document that's required for each of those steps. And it will have the dates when they have to happen, and it will have the parties who are responsible for each of those. And that will be circulated constantly between everybody, between all the different parties, showing where we're up to in all the different transactions. So that was actually something I was working on today, was updating one for a transaction that I'm doing, so that we bring it up to date with all the different parts that we've done, and then we could see what was left.
Okay.
Yeah, similar. I have a closing agenda, what documents that we're required to complete. it's between me and my principal lawyer, so we usually divvy up the work. There's a date that everything needs to be done. And then once those documents have been finalized, then we call on the client, have them sign off, and then we exchange our documents with the opposing counsel.
Okay. And it may be that if there's certain trigger dates, where if there's certain milestones that have to happen, always a backup is to use what we call a bring forward system. For those of you who aren't familiar with what a bring forward system is, it's basically where you have two calendars or two forms of reminding you of important dates. This is used in corporate law and in litigation. Very, very heavy in litigation, bring forward dates so that you don't miss deadlines for court dates and for filing of documents. And it's exactly the same if you're dealing with an M&A transaction or a real estate transaction. If there are hard dates where things have to happen, and you always do it in duplicate, at least in duplicate, so that if one system fails, you have a backup. And that's actually a requirement by the Law Society, that you have a system in place for that. And so it can be, quite often there'll be a paper calendar that you'll have, and everyone will write those dates in. And then you'll also use your Outlook calendar, if you're, for example, if you're using Outlook as your email server. And then it can also be relying on your paralegal, who will then document everything as well. But it will be two forms that you need to do things with.
Okay.
Yeah, exactly.
Okay. There's one last question from Shalini, and I think she means what specific softwares are used. I'm not sure. Are there specific softwares?
I'm sure there are if you're doing litigation and you're using project management software. I'm sure there are where you're, and so where I talk about project management software for litigation, it's where it auto generates various different documents for you. And I'm sure as part of that process, there is a bring forward system in there. I know for corporate documents, if for anybody does corporate registers, they use a system called ALF. ALF does have a BF system in place. However, it only has one. So you still need to have a second system as well. So you'll have the system in ALF, but they'll still have to document it somewhere else.
Nice, interesting. I think that's all the questions that we got. So thank you so much, Siobhan and Eric. This has been so informative. You took me back to my PLTC days when we had to do purchase and asset management, all those kind of things. It was really interesting. So thanks for giving us this talk. And if you want
thanks for inviting me.
Yeah, thanks so much for coming, Eric. Thank you for sharing all your tips and knowledge on APAs, otherwise asset purchase agreements. To have you join us here today and share your experience. And Pearl, thank you for moderating. You did a fantastic job.
Yes, you couldn't help yourself, could you, Siobhan? You had to go through the slides.
It's just easier. One of us had to do it.
Guys, I'm glad we did that way, to be honest. It's easier.
It's much easier. But guys, for those of you who are going through the NCA process, for any of you who are at law school, for those of you who are going to be doing the bar at some point, M&A transactions do come up. So asset purchase agreements, share purchase agreements of some description will come up at some point through that process. If you want to read up a little bit more, there are lots and lots of resources that we've put into the slides. We will circulate them. They will be put onto the as we said at the beginning, the Global Lawyers of Canada members Facebook group, not the page, the Facebook group, because you can't attach attachments to a page. So you'll be able to see it there. But one resource you can go and look at right now is if you go and look at the PLTC material for the BC Law Society, they have a whole section in there about asset and sale purchase agreements. And you end up actually drafting one as part of the PLTC process, but it actually does set out in that material all the different regulations and codes, at least in BC. Now, obviously, in different provinces, they'll use different corporate codes, but it might give you a kind of an idea of the types of things that might come up. So you can have some homework if you want it. Next week, we have another session on Thursday. Can't think who it is, but I'm going to tell you it's going to be amazing. It's going to be fantastic. You're going to want to join us. It's 5 p.m. Pacific, 8 p.m. Eastern. We have 2 more sessions before we break for the Christmas festive shutdown. And then we will be back in the new year with a revamped look at virtual mentor office hours. But if you have any questions, please do reach out to Pearl, myself, or the fabulous Eric. We'll be happy to try and answer all of your questions. And please do give us feedback. If this session was helpful, please do let us know. And if it was also rubbish, also please let us know. And then we can improve it for the future.
Yeah, please feel free to reach out. Some of you have already asked me about my NCA journey. How do I come about articling in Ottawa? What are the things and steps that I need to do? Yeah, send me those questions. I'll do my best to answer them. If you want to schedule a phone call or a virtual meeting, please feel free to reach out.
There you go. Now you have a contact in Ottawa, everybody.
Yeah.
Thank you so much. Thanks for joining us. And we